Hey everybody, welcome to another episode of Foreclosure Help 777. My Facebook page is Sue Your Lender, Fight Foreclosure and Mortgage Fraud. It's a Facebook group. Join the group and you'll find out more information on how to save your house. Today we're going to talk about foreclosure mistakes you don't want to make. And so these are the most common mistakes people make when they're trying to initiate foreclosure defense to save their homes. If you're filing as a pro se person and you want to file a complaint in court to save your house, mostly you'll want to do it in federal court because most of the time they break the federal laws and that's the right jurisdiction. So let's talk about what are the most common foreclosure mistakes that you don't want to make. The first mistake most people make, not realizing it, is they don't file their complaint in time. They wait too long to sue, and then they end up going and filing for bankruptcy. Now you'll see all kinds of remedies online, and this one I just took off the internet talking about bankruptcy will stop a home foreclosure. They talk about the automatic stay. And you know, I disagree with filing bankruptcy. I just don't think that's the best way to handle foreclosure. They are not going to get you your house. They are limited and they're not going to provide you long-term relief, and it's going to mess up your credit ratings. And so if you have, I don't know if you have good credit to begin with because you're going through a foreclosure, but filing bankruptcy will mess up your credit. That's something to think about too. Of course, these bankruptcy attorneys, they want you to go with them because they're trying to say, oh, you know, you don't have any other options to save your house. They're talking about how non-judicial foreclosures work in the state, and you know, they tell you how it goes and how you don't have any choice but to do this, but that's just not true. It does say here, yeah, that the lender or trustee must mail notice of foreclosure to the borrower 20 days or more before the date of the sale. The lender or trustee must publish a notice of the foreclosure sale in the newspaper daily for 20 days or once per week for 4 weeks, depending on the circumstance. Once a non-judicial foreclosure is initiated, it's typically completed within 45 to 60 days. Of course, the initiation of a foreclosure does not have to mean the loss of your home. There are actions homeowners can take to halt a foreclosure and keep their property. And they're telling you these are your options. Guess what? They didn't give you all your options. They just say, oh, you can reinstate the loan. You could do a loan modification probably, right? Redeeming the home. You can reinstate the loan, whatever, redeem the loan. But, you know, and then they say, oh, you can file bankruptcy. Chapter 7, Chapter 13, whatever. And then they say to use bankruptcy because of the automatic stay. Well, that's not going to help you long term. And a lot of times banks will file a complaint to lift the automatic stay. And sometimes the automatic stay doesn't always work, so bankruptcy may be able to help get rid of your second mortgage. Yeah, maybe, but it's still not the thing that people should do. And I think a lot of people jump into bankruptcy in order to save their house from foreclosure. And I just don't think that's always the right move to go. The next thing people make a mistake is when they file their complaint, they forget to file lis pendens, which means pending lawsuit. Now, when I filed my complaint in court, I filed a lis pendens, and this is what it looks like. I know I've showed you guys this before, but it's pretty important because this is what stops them from taking your house. If you're in a non-judicial state, you file your lis pendens after you file your complaint in court, because you got to put that court number on your lis pendens there. You go to the county recorder of deeds and you file your lis pendens there. And it's basically explaining the lawsuit here between myself and the other party. And it explains the deed, the book number, and the property description, which my house, what I used to have, it had a pretty big property description. And that's it, you know. I just sign it, notarize it. I had a verification. I wasn't playing around. I got it notarized too. And that went to the county recorders, the deeds office. You don't file that with the court. You file that with the deeds office. Anyway, that's one mistake. A lot of people do not need to be making that mistake. And again, waiting too long to sue. Because once they get your house sold, there's not a whole lot you can do. And unfortunately, people do that sometimes. Another thing people need to remember to do is to put a notice to plead on a cover sheet on your motions that you file. And here's a sample notice to plead that I made. It basically says the following. And this is to this is when I was the defendant, trying to save my house from foreclosure. And the plaintiff was the bank, and I was filing this in the state court, not the federal. But I had to file a notice to plead, which is on the cover sheet. And it basically states that you are hereby notified to file a written response to the enclosed defendant's amended answer with new matter and counterclaims to plaintiff's complaint within 20 days from service thereof, or judgment may be entered against you. And ta-da-da. And I put that in there. Now, you just don't want to forget any of the rules that the court has about how you file your motions. And so if you go to your court, let's go to the court real quick. I'll show you where the rules are. This is the federal court in Missouri. When my friend Sabrina, she's filing against the banks there. And she goes, hers is in St. Louis, Missouri. So this is her court that she goes to. If you go down here, it'll say forms, docket, and local rules. And if you click on the local rules, that's what you need to read these rules about how to file your motions so you don't make mistakes. That's where they'll get you. If you make a mistake, oops, you can file an amended complaint or an amended pleading if you do make a mistake, just so you know. But you should read all your rules first and make sure you understand all the rules. And if you don't understand your court rules and you're trying to understand them, you can always send me an email, or you can leave a comment in the comment section and I will help you understand them better, because you got to understand your court rules. If you want to play the game, you got to understand the rules. Okay, so now we went over the rules. We went over the cover sheet. Let's go over another big mistake people make, and you don't want to make this, and that's this. There are foreclosure rescue scams out there that take advantage of people. I'm not saying Fraud Stoppers is one of them, but I've heard things about them that they don't help people as much as they should, and they charge high fees. That's just one of the many fraudulent foreclosure rescue scams. If they tell you, oh, we can stop your foreclosure in 24 hours, or we can file this or do that, be very, very careful, because people have gotten defrauded by these people. And on my page, I actually posted about this today. The Sovereign Citizens Movement. The FBI went after these people in Pennsylvania. And so be very cautious about these people, because they will tell you, oh, you can win a foreclosure by going to court and saying you're a sovereign citizen, and a foreclosure doesn't, mean anything to you. But that doesn't work. None of this works. So they lie when they say it does work. because really it doesn't, and it will get you into trouble if you do this. So stay away from anything that sounds too good to be true, because I'm telling you, it isn't going to work. If you want to fight to save your house, you're going to have to learn how to do it like an attorney. Now, I'm not an attorney, but I tell you what, I learned a lot by fighting the banks myself. And that's why I'm here today, to help you guys learn how to fight the banks too. So don't fall for those rescue scams. They don't ever work. You're going to have to do some work. If you need help with motion writing, I can help you with that. I have plenty of experience. I learned from my mistakes, so I can help you guys. Now, the other thing you want to remember to do, a common mistake people make, is when you're filing your complaint, you forget the summons, which is right here. Here's a sample summons. This is from the court where Sabrina's going after Midland Mortgage. And the summons goes in front of the complaint, and it tells the party that within 21 days after service that they have to file a response. Now, if you do it by certified mail and not by a process server, it's 60 days. But she did it both ways. She wanted to make sure they got it. They actually got the certified mail before they even got the process service, but they only have 21 days. So in a way, it's kind of good, because maybe they'll think that they have more time than they actually do, but I doubt it. It would be nice if they didn't. Anyway, that's another mistake people make, is they forget the summons when they're filing their complaint. You got to have that summons, and if you need help with that, let me know. I can help you with that too. And then let's see if we've covered everything. We talked about the sovereign citizens that got arrested. And Liz pendens, we talked about that. What is this that I put up? Okay, so the other thing I wanted to go over was you want to put a proposed order with whatever you file in court. In this case, I filed a default judgment against the banks because they took too long to reply. And so this is what a proposed order looks like. And now this blank day of blank 2012, upon consideration of Pennsylvania Rules of Civil Procedure, the plaintiff's motion for default judgment is hereby granted, and the defendant's motion to dismiss denied. It is further ordered that the defendants are forever barred from asserting any right, lien, title, or interest in the land inconsistent with the interest or claim of the plaintiff set forth in the complaint. Action to quiet title granted, and the mortgage and note affecting any rights, liens, title, or interest in the land hereby declared null and void. Cost tax to defendants. And then it says by the court, and there's a place for the judge to actually sign. And this is just something I put in with my last motion, telling, you basically want to put a order, proposed order is what it is, a proposed order with what you're filing, so that if the judge sides with you, he'll just sign it. Would that be nice, huh? That's not what happened in my case, obviously, but you have to follow the rules of the court and have your proposed order included, just so you know. And one more thing I guess I should say, guys, when you're filing your motions in court, you want to have your verification. You want to have it signed and notarized. And then you want to also have your certificate of service showing that you've served the other side. Now, in this case, the attorney for the bank was this guy named Andrew Sovin in Philadelphia, and he's the attorney that's representing all the parties. So every time I file something in court, I have to do a certificate of service stating that I've served him. And I do. I always make sure I send it certified mail, return receipt. That way I can prove, if they say they never got it, I can prove that they did get it. So it's very important that you don't make that mistake. Okay, guys, well, I hope that these little tips are helpful for you guys when you're suing your bank. Join us on my Facebook group, Sue Your Lender, so we can help you better if you need help. Otherwise, leave comments Don't forget to subscribe, guys. And let me know if you have any questions. I'll be happy to answer them. Y'all have a wonderful day.